Often, if you prepare a gift tax return or an estate tax return for filing, you'll need to substantiate the values on there, especially for non-cash, illiquid assets. And that might require an appraisal from a qualified appraiser. But the qualified appraisal does open the appraiser up to penalties potentially. It's a little known fact under the tax code. So this is a presentation for appraisers and attorneys and advisors who deal with valuation issues for tax purposes, as well as individuals who might need appraisals for gift or estate tax purposes, for which a valuation discount might be claimed. Now, appraisals often have to accompany a value because you can't just pull a number out of thin air and put it on the return. The IRS is less likely to take your word for it. I'm Griffin Bridgers, and this is 10 Minutes with Griffin. For today's episode, episode 223, we're going to dive into Code Section 6695 Cap A, which deals with appraiser penalties. Now, these are penalties imposed on an appraiser and not on a taxpayer or tax preparer. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. A little bit about me. I'm an attorney with the law firm of Hutchins & Associates in Denver, Colorado, but this is not an advertisement for legal services. I provide estate planning education and estate planning media, so if you'd like to register for my newsletter, which provides more info than these videos, you can sign up at griffinbridgers.substack.com, and if you need a speaker for your organization, email me at griffin.bridgers@gmail.com. Now back to the presentation. Now, I'm really just taking a surface level view here. I'm not an appraiser. I'm not an expert at appraisals or the credentials required to be a qualified appraiser. But this is just kind of one of those I need to plant the seed types of presentations for everybody to think about as you're out and about in the gift and estate tax world, getting values and reporting those to the IRS. So, typically, if you're filing a gift tax or estate tax return, for anything that's not cash, you're going to require some sort of accurate appraisal or valuation. Now, I've previously talked about publicly traded securities and how they have their own valuation rules, the average of the high and low trading price on the valuation date. Sometimes those are easy to get, sometimes they're not. But for non-publicly traded assets that are illiquid, like real estate and closely held businesses, you're pretty much always going to have to go find a qualified appraiser to give you a valuation report. Now, we've previously talked about the availability of discounts for things like lack of control and lack of marketability for those types of assets, and claiming those discounts will usually require an appraiser's opinion of value as well. So this presentation is not about how do you go about doing that or how do you find a qualified appraiser, but it's more looking to the issue of IRS penalties if, for example, you want to circumvent the process and be a quote-unquote appraiser yourself, or if you just want to hire anybody off the street to give you this value. Now, that anybody off the street, whether they're qualified or not, is going to run the risk of a penalty for any appraisal they provide if there's either a substantial valuation misstatement or a gross valuation misstatement. Those are different degrees of valuation misstatements. And usually what this is going to result in is a situation where the value is understated, which results in an underpayment of tax by the taxpayer. So the taxpayer has to deal with their own penalty dealing with the underpayment of tax and the degree of that attached to the substantial or gross valuation misstatement. But in addition to this, if the IRS really wants to go after blood, they can go after the appraiser for the penalty here for wasting the IRS's time with an inaccurate appraisal. Now, when this penalty kicks in is at this hurdle point when the appraiser knows or reasonably should have known that the appraisal was being used in connection with a tax return or claim for tax refund. So, for example, if you're having an appraisal prepared specifically for estate or gift tax purposes, that's usually going to be in the scope of engagement. It's going to be stated in the appraisal report. So that's a pretty low hurdle to get over. But at the same time, sometimes you might have an appraisal just for shareholder purposes within a company itself, and you may be able to pull double duty and look at that for gift or estate tax purposes, but the valuation might be different. There might be no discounts depending on the use for which the appraisal is deployed. Now, that aside, another requirement that's not stated in this code section but is implied in subsequent IRS rulings and advice and everything is that the appraiser has to have received some gross income in exchange for providing the appraisal. So if you have a free valuation report, there's likely not going to be any sort of appraiser penalty. So one area where this might kick in, for example, is I've noticed an increasing number of realtors who will provide opinions of value for free, especially for residential properties, with the hopes of maybe getting the listing from the estate in the future. Now, there's no appraisal penalty there if there's no gross income for that appraisal, but it's important to note that the sale price could ultimately end up overriding that opinion anyway, depending on how many or how long separates the valuation event and the actual sale. And also, one must question whether the commission to the realtor could somehow factor into this appraisal fee. But that's its own issue that we're not going to dive into in great detail. Now, the penalty amount. It's a little confusing how the statute is worded, so it helps to kind of rework things and start with a waterfall. Starting out, you need to look at the total gross income that the appraiser received in exchange for providing that appraisal, and your starting penalty is going to be 125% of that appraisal fee, the gross income there. Now that could be reduced. To reduce it, you have to go to the underpayment of tax. So your penalty is going to be potentially reduced if you can look at the greater amount of 10% of the underpayment in tax that resulted from the misstatement, or $1,000. Take the greater of those two amounts, 10% of the underpayment or $1,000, and if the greater of those two amounts is less than 125% of the gross income from the appraisal, then you can use that lesser amount based on the underpayment of tax. Now, it's important to note, too, that procedurally this has been up in arms, and we'll touch on that in a minute. In fact, just today, IRS Chief Counsel guidance was issued that revealed the IRS position that the agent need not interview the appraiser nor request documentation from the appraiser prior to assessing this penalty. So this could come without any warning if you're an appraiser. So you could have a taxpayer negotiating on your behalf, and you may not want to have that type of a situation. So that being said, we have to get into what exactly defines a valuation misstatement. Now, any valuation misstatement isn't going to be enough to assess this penalty. It has to reach some degree of extreme nature that the IRS will really step in and say, this is enough to trigger the penalty. So there's 2 degrees, substantial and gross. And for purposes of the penalty for appraisers, these two aren't really distinguished. They don't really affect the penalty itself. These are more definitions used for the taxpayer penalty for underpayment of tax, but these are still expressly referred to in the statute. The first, the lesser degree one, is a substantial valuation misstatement. This is a situation where the ultimate appraised value determined by the appraisal is 65% or less of what the IRS deems to be the correct value. So, if you've noticed that, that's a 35% discount, and ironically, that almost perfectly correlates with what a lot of people consider the top of the bell curve for the combined lack of control and lack of marketability discount of 35%. So it's kind of funny how that works out. So I guess the big picture there is that if you want to play with fire with discounts, as long as your discount is less than 35%, maybe you're saving the appraiser some fees, and maybe you're avoiding a substantial underpayment penalty for this change in value, but that's neither here nor there. That's a subject for another time. And from the taxpayer's perspective, there's no penalty unless the underpayment of gift or estate tax exceeds $5,000 here, but there's no express reference in the code as to whether this would reduce the appraiser penalty. So you could still have no payment of estate tax or gift tax potentially, but still have an appraiser penalty, which makes sense because this appraisal, especially on the estate tax side, could determine the basis of property. Now you also have a gross valuation misstatement, which is where the appraised value is 40% or less than the correct value determined by the IRS, which once again increases the taxpayer penalty sometimes by double, but doesn't seem to increase or decrease the appraiser penalty. Now there's some other little things here too. The appraiser isn't just stuck defenseless with this penalty. The appraiser can show that the appraised value was more likely than not correct, which is kind of an easy evidentiary standard in the grand scheme of things to get to. You don't have to show clear and convincing evidence. You just have that more likely than not easy hurdle to get over. That could even be less than a 50% chance depending on the situation. Now, it would seem intuitive that there'd be no penalty if there's no estate or gift tax that's due, but that's not the case. In that case, you might still have a penalty of $1,000 that could kick in because you have the greater of 10% of the underpayment of tax, or $1,000, which can come in if you're looking at amounts that are less than 125% of the appraisal fee. So even if you're just filing to use your exclusion amount for a zero tax estate or gift tax use of exclusion, there could still be a penalty floating out there for the appraisers. Now there's one other issue noted by practitioners, that the procedures on this are in flux and they have been changed. There were some AICPA comments dated June 16, 2020, just on my brief research, where they're really kind of questioning the IRS removal of an additional layer of appraisers and looking at, okay, well, could the IRS, try to circumvent the use of appraisers in general and maybe even have an agent who's unqualified try to come up with a value to inflate penalties? So that's another issue to monitor and keep in mind and look at. And ultimately with these types of issues, sometimes depending on the amount at stake, they end up being litigated over 10 plus years with a tax court opinion, the IRS having their own valuation experts who testify, the taxpayer having their own valuation experts who testify. So you're kind of opening a rabbit hole here if you want to avoid the penalty. But at the same time, there are ways to avoid it, but those ways aren't necessarily fully established on the defense side, other than the more likely than not evidentiary standard. As always, if you have questions other than legal advice, which I can't provide, or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.